To another exciting episode of the Conscious Counsel podcast with your host, Cory Sterling. That's me. I hope that you're excited for our time together. I'm really excited that it's just you and me hanging out and chilling and enjoying. As always, there's one intention, there's one reason why I put this podcast together, and that is because I want to help you protect and grow your wellness business with confidence and clarity. That's what I'm about. That's what I care about. Your dreams, your community, whatever expression you have of yourself in the world, I want to help you build that with both confidence and clarity. And with the variety of experience that I've had as an health and wellness entrepreneur with a couple of different ventures in my life and working as a lawyer for more than 8 years with more than 1,600 clients in the health and wellness space, I bring all of my experiences to share with you and to be of service with you. So this week we have a really fun. Law is fun, and this topic is fun. And this week's topic is called, and I'm getting ready for my up voice intonation, can I really get sued for that? I feel like that was good. Can I get sued for that? Yes, this is the age-old question. Can I really get sued for that? And one of the biggest areas and exposure of risk that I see my clients going through is the risk of getting sued, and sometimes they do get sued. And I'm going to explain to you a little bit about what the answer to that question of, can I really get sued for that? What the answer is, and what sort of framework and tips and tools we have around it to be prepared in the event that you do get sued. And obviously we want to avoid that at all costs possible. This matters to you because getting sued is, let me think of 2 words. It's not fun, okay? We could say law is fun. I can say that with confidence. Law is fun. Law is fun. Law is fun. Getting sued is in the category of not fun. And any time that I have been brought on to support a client who is going through a lawsuit, I'll leave out the expletives and the inappropriate words, and I'll just leave it as not fun. But it's not fun because you're very stressed. You're not sleeping that well. You can't focus on your business any longer. You're constantly worried and in a state of anxiety, and you're paying tens of thousands of dollars in legal fees to take care of a problem. And none of those things are fun. And there's another part to the process of getting sued as well, and this is part of why it matters, is there's such an element of uncertainty that is present when you're going through a lawsuit. And a lot of people don't do well with uncertainty, even though it is the basis of our reality. We're not really certain of anything. But when you're getting sued, or you think you're getting sued, or you start negotiating settlements, I've just seen clients crack because they're not having fun and they can't take it. And a lot of the times they're like, okay, I don't care, I'll just pay everything just to have this over with. And I'm like, no, it's my job. I'll fix this for you. But I need your help in figuring out what that looks like. So there's a lot of reasons why this particular episode matters and why this topic is so important. In North America, we exist within a highly litigious society, more so south of the border than north of the border, but it's real. And it doesn't matter how or why we got to be this way, but we are this way. And as always, I'm going to share a story with you about a client of mine who got sued that will help inform the particular question that I asked at the beginning of, can I really get sued for that? So what you need to know about this is the answer is yes, you can get sued for that. So I don't even know what the potential issue is that's coming up. The answer is that yes, you can get sued for that. And we don't like getting sued. But there's one thing that has to be understood about the nature of how the legal system works, and that is that it's a free system and it's open for everyone, equally accessible, and that at any point someone can sue someone else. At any point for any reason. To initiate the process of being able to sue someone, anyone can start it with anyone. So for example, let's say I'm having a bad day and I'm upset with someone. I, Cory, could go and fill out a notice of claim against that person and file a lot. Like I could invest money and time to sue that person, and then I could sue that person. Now, whether or not the claim has any merit is a completely different situation. I'm going to talk about legal position in a second, as you remember. Legal position is the first episode I recorded. It's the most important one to listen to understand everything that I talk about. So you have to understand that concept, that idea in order for all of this to make sense. But short answer, yes, anyone can sue anyone because everyone is allowed to submit the appropriate documents and follow the process to sue someone else. Now, once someone has filed a claim and has served it on the other person, the person who has been sued has an opportunity to respond. And at this point, this is where you'd be able to say or demonstrate or show that the person who's suing you actually has no legal standing for doing so. So, cool, Cory was just having a bad day because he ran out of yerba mate, and that's why he's suing me for whatever reason I was suing them for. If this action moves forward, I reserve the right to counterclaim for emotional distress and damages and blah, 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 and all of the sorts of things. And that's really it. So when someone has a legitimate claim to sue someone, what it would look like is like, hey, company A and person B had this problem, or like as an example, something I've been through with my clients, someone got injured in a yoga studio in a yoga class, and we were unable to come to some form of settlement. I was brought on afterwards, and the studio got sued. And the letter said, hey, my client was doing yoga in your class on this particular day, and this is the situation that happened, and they got hurt, and they never agreed to release you from liability because the waiver of liability came from a template. This really happened. This is a real story. This isn't the story, but this is a story. And now my client can't work, can't be a mother anymore, is suffering all of these headaches and problems, can't look at a screen, can't drive. This is the dollar value amount for how much they've suffered, and pay this amount or we're going to sue you for even more. And at that point, then when you're responding, it's something more substantial than, someone just suing someone out of a joke or for no reason or without any merit. Now, the reason why having specific, industry-specific and customized legal agreements is because in the event that someone sues you, and we just know, like, if there's one thing that you've taken so far, and the story that I'm going to share really demonstrates this, if somebody wants, they can sue you. You don't need any standing, you don't need any legitimate claim. You can sue anyone, but once the process gets going, then you can stop it by showing they don't have a cause and that if they continue, you're entitled to penalties and all of that stuff. But what's really important to know is the ability for you to move past that first stage of whether or not they have an actual claim or not is going to be dependent on what is written in your agreements, your contracts, how specific it is to the industry and how specific it is to your business and how specific it is to what actually took place and what actually happened. So the more specific your agreements are, and the story I'm going to tell you has to do with a waiver of liability, the more specific your agreements are and the more detailed they are to your business and the industry that you operate in, the better protected you'll be so that if someone does sue you, you can very easily demonstrate and show, hey, you're claiming this happened. Have a look at the signed contract that you signed before we allowed you to participate with us. Clearly, in this signed contract that you have, you agreed not to hold us responsible. Therefore, your claim has no merit. If you continue to pursue it, we reserve the right to counterclaim for all of the money and all the damages and all the penalties, and then it just goes, and that's where the problem will go away because the other person or the opposing counsel will say, okay, we actually don't really have any case in this instance. Now, the story I'm going to tell you happened with a studio of mine that I was brought on afterwards to support. So for me as a lawyer, I'm a big fan of proactive law, being in control of the situation, and that's why I record podcasts and do free consultation calls and try to get on and share as much as possible out there because I want the people who I care about, health and wellness entrepreneurs, to have the confidence and clarity to understand how to navigate these situations. But in this situation, we were practicing reactive law, and the situation was out of my client's hands because they didn't have the proper agreements. They were using a template for what happened. So someone came to the yoga class. someone was on the mat, someone got a rash after being on the mat, and then afterwards they sued the studio for millions, with an M, not a B, not a T, an M, millions of dollars for all of the impact that this rash had on their life, which they claim came from using that particular yoga mat. So you and I hear it. It sounds pretty absurd. Answering the question of the episode, can anyone sue anyone? Yeah, they can put this claim in. They can choose the amount that they want to sue for, all of that stuff. And I was brought in afterwards, and I know everyone remembers this game. I had a consultation call with a client. Cool, I want to help you. This sounds really silly. You shouldn't have to put up with this. Send me a copy of the signed agreement. That's what I say every time that I run into a problem with my clients. Send me a copy of the signed agreement so that I can read it and understand what the client's legal position is. In this case, it was a templated agreement. It was for yoga. It didn't have any provisions which included the specific equipment that they would use, nor did it mention the specific risks that can come from someone using the equipment. And it's so silly. It's so silly because we're talking about it now, you and me, we're having a chat, and you're like, oh, obviously there should be something that says that. But the fact that there wasn't anything there, it didn't mean that the person making the claim still had a lot of things to prove. A lot of things to prove. But what it did not give me the power to do as a lawyer was to unequivocally, immediately dismiss the claim. And I know that if this person was using our waiver of liability, that includes all of the equipment and specifically lists injuries as it relates to the equipment, I would just be like, hey, this is our response. If you do anything further with this, we're going to come after you for all that we can. You signed an agreement saying that you would not hold the studio responsible for anything, any risks or issues or problems that come out from using the equipment or the equipment itself. But we didn't have that. And then what happens is now you get drawn into some form of, we can respond, but our legal position is not A+ airtight. What I want for all of you is A+ airtight legal positions. That's what I care about the most. And so now the studio owner who's getting sued for millions of dollars engages me and ends up just paying a lot of money for something that was so easily avoidable from the start if they had specific agreements for them in their studio. And that's why I'm like, I don't want to get paid a lot of money having to put out massive fires for people. I would rather be of service up front, not have this person super stressed out and sad and wanting to close their business down because some crazy person is making some crazy allegation. But at the end of the day, what matters is your legal position and what agreements were signed. So I hope that this story makes sense to you and, you sort of walk away with this episode, after this episode of understanding, okay, what is it possible for someone to sue someone? Yeah, anyone can sue anyone. Anyone can sue anyone. You can sue your husband. I don't think you could sue your dog. But you could sue your husband. You could sue the owner of someone else's dog. Anyways, anyone can sue anyone. But what I care about and where the rubber hits the road is, okay, cool. Someone sued me. Do they actually have a claim? And how strong is my legal position to be able to support me? And this is why having specific, industry-specific agreements that reflect the relationship that you have and the actual way that you conduct your business is so important. So I hope that you care about this and that it really resonates and comes through, that you need to have documents that are specific to your industry and your business, because that is what will protect you in the event that someone decides to sue you for no reason. And that's it. And that's what's happening here. So I hope that you enjoyed this episode. I really loved it. I think the best thing to do is for you to follow us on Instagram, and just our handle is @ConsciousCounsel. Give us a follow, give us a like, shoot us a message. If you have any questions or you want us to do a free consultation, just hit us up and we're here for you. And I hope that you enjoy connecting with us on the interweb. I hope that you love this episode. I hope that it was really interesting for you and that you learned something. And remember, whatever it is that you do, make sure you work with a lawyer who loves you.